When I was invited here, I really didn't know what this institute was the center was about and what was exactly cultural diplomacy. And by hearing the previous speakers, I fear that I might be not completely out of focus, but really not really in the same line that the other speakers. So I will try to make it rather brief and not to bore you at the time at this time of day. So my topic will be a bit different actually, and I don't know if any of you have any idea about what copyright is, or if it's something completely new to you. And I won't go into the details of copyright, but actually copyright is my field of expertise and of research, and I've been doing copyright for almost 20 years now, and I'm really trying to work to get copyright a balanced regime for protecting culture and protecting creators, but also for allowing culture to develop and flourish. And my purpose was just to show today the relationship between that balance in copyright and the cultural diplomacy. I would like to explain to you, for me, what would be the role in that cultural diplomacy efforts and how the current European landscape is dealing with that objective. I know that some of you are not from Europe, but you will see that actually what happens in Europe is happening everywhere in the world. And I would like then to focus on some issue, to give you some examples of my point. So first, the role of copyright. So copyright is that field of law that grants property rights to creators and to an industry of creation also to protect their works against any use with no authorization. So it has been created in the 17th, 18th century, and now it's really all over the world with a same level of protection everywhere in the world. And actually, copyright might be explained by different reasons. There are certainly cultural reasons, because copyright is there to protect creators, to protect creation, and I think that it should be also there to protect the dissemination of culture. So not only to protect the creators, the artists, but also to protect them in a way that they feel safe in disseminating their works, because their work will be protected. But copyright should also be an engine for further dissemination of culture. But of course, that cultural objective is rather forgotten right now, because the economic objective has regularly taken over. And because copyright is also part of an economic sector that is very big, it is not only about creativity. Sometimes you have copyright will also protect, for instance, software. And software, okay, it can be creative, of course, but it is a bit far away from culture. And it's also protected by copyright. So you have a larger economic sector that rely on copyright for its economic survivance. And copyright is also used to incentivize innovation and creativity, to sustain the creativity from an economic point of view. But I am of the opinion that there is another motive in copyright that is overlooked. It's regularly overlooked. It's a sort of democratic objective. And copyright, as I said, was created in the 18th century. And it's not a coincidence, because I think that it was at the time where the public sphere emerged in Europe. The public sphere, as described by Jürgen Habermas, as a sort of society where people could discuss, could, for the first time in history, intellectually engage with each other, politically engage with each other, and not only a sort of hierarchy in the society, but people could really take the streets, also take the theater, take the literary cafe and meetings and discuss. And so copyright was there to disenfranchise creativity and culture from censorship and from the control of the kings, but to just put copyright in the market and in the public sphere so people could read, could discuss, could stage plays, theater plays, and things like that. And this public sphere dimensions, for me, is very important in copyright. Those justifications, you can find them, for instance, in the many legislative texts around copyright, and I won't go into detail because this is the boring part, maybe, of my presentation, but just in a few words. For instance, in the European Charter of Fundamental Rights, it is said that intellectual property shall be protected. It's a very strong affirmation, and maybe it's a too strong affirmation because it shouldn't be an end in itself. You know, copyright should not be protected as an end in itself. It should be protected because it has some objectives. And those objectives, you can find them in different texts in Europe. I won't go into details here. You have cultural aspects too. There is one directive in Europe that says that copyright is a great importance from a cultural standpoint, but it's not really at the forefront of the objective. It's always repeating the protection of innovation, investment, so really an economic focus that is given to copyright. The need for a balanced protection is also repeated by a number of lawmakers in Europe, but also internationally, and it's always a balance between the protection of creators, but also the access to works, the freedom of expression, the free movement of information. And you can find those also in many texts. I won't go there. But actually, for instance, in Europe, despite this declaration, copyright is really much protected, and it's always repeated that copyright should provide to creators a high level of protection. And it means that actually nowadays the picture of copyright in Europe, but also in the United States and in many other countries, and this is the level of copyright protection that we tend to force on developing countries too, would look like that. So, you know, it would be a sort of big tree with really heavy branches, with no breathing space of any kind, but really a tree that has grown rather in an anarchistic way, sorry, with no really control. And this is a big tree, very strong, but also very weak because it's really suffering from its own weight. And this is, I think, a very big problem in copyright today. And this strength in copyright, this overprotection, for instance, can be illustrated by some points. And here I will go very briefly, but to give you some examples, even if you're not familiar with copyright. In copyright nowadays, you can almost protect anything. The subject matter, it's not limited to cultural creation. We can protect software, but you can protect also very little pieces of device, of instruments. You can protect a manual for your fridge, for instance. It will be protected by copyright. You know, how to make your fridge work will be protected by copyright. So actually, copyright has been cut from cultural objective of protection of creation. The rights that are given to creators are also sometimes overreaching, and they reach things that should not be protected, shouldn't be prohibited. You have exceptions in copyright, so cases where the lawmaker says this is a use that is allowed. It's not prohibited by copyright, and it's, for instance, exception for education, access to information, freedom of expression. But those exceptions are really, really limited, and they tend to be even more limited by some legal mechanism. The duration of copyright is 70 years after the death of the author, almost everywhere in the world. You have even longer duration in some countries. And this duration is regularly lengthened because at some point, some stakeholder says, oh, it's too short. You know, for instance, a few years ago in the US, the duration of copyright was extended because Disney company suddenly realized that Mickey Mouse will be in the public domain and will not be protected anymore. And Disney company was one of the strongest fundraisers of Clinton. Clinton was the president at the time, and so there was a law in the US to just lengthen the duration of copyright so Mickey Mouse would not fall into the public domain yet. It will eventually, but we don't know. We will see if it will. some point be out of copyright protection. So there are a lot of things that happen in copyright. There is a strong economics focus too that tend to overlook the cultural motive of copyright. You will not see that. It's just in that phrases I said that copyright is not much like, you know. Nowadays, copyright is not something that people like, you know, regular people. And for instance, in Europe, you can see the emergence of pirate parties in almost all countries. And it shows that copyright is really much disliked by people because people think that it's an unfair monopoly. And it shouldn't be an unfair monopoly because it's a protection for creators. It's a protection for creation. And it's also the regulatory stage where creativity can take place. So it's not very good that the excessive protection of copyright is finally what weakens the copyright protection and the protection of creators. So my point is that maybe we should start to prune the tree of copyright, maybe to try to heal it and try to make it, to reduce it in a bit. So I will just give you 2 examples, and you will see that there are different examples. I put 4 here, but I will just focus on 2. And all those examples actually would be to promote cultural diversity, literacy, and diplomacy. The first one is the protection of creators, because when I say that copyright is excessive, a lot of people immediately put me in the box with Pirate Party, with the people they would like copyright to be abolished. And I'm not in that box because actually I'm really in favor of copyright because copyright is essential for authors. But actually copyright as it is now does not fulfill its objective of protecting the creators. For instance, most of the time authors waive their rights by contract to publishers or producers. Of course, it's important for a young author, a young musician, a young writer to have a first contract for production, for publishing, because it's really a success. And at that time, the artist is so happy to have this first contract that he don't really care of the content of the contract. Or he doesn't have the lawyer to advise him as the publisher and producers have a team of lawyers. So creators are usually the weaker party in that negotiation. And there are a lot, sometimes, most of the time, you sign a contract transferring your copyright to your publisher for the whole duration of copyright. So for the 70 years after your death, you know, and you agree on some remuneration, but you don't know yet what will be done with your work. You don't know yet what will be the success. And a lot of creators feel trapped at some point in the contract they have signed at the beginning of their career. And for instance, I put a quotation here from Morrissey, the Smith singer, and it's recent biography. He said that when he signed the first contract with his band, he said that we had no idea what we were signing in an act of legendary mental deficiency. It's not mental deficiency from those artists. It's just the fact that the law should be there to protect them, but it's not really working in a way that gives them protection. They are just weaker parties in that contract. And so there is a need in Europe, but also elsewhere, to really focus copyright on a strong protection of creators in contract, and not only give protection to the industry, publisher, and producers. There are some legal technical points here. I will not bore you with that. Another example, I will skip those, just try to, I will just give you 2 other examples. For instance, the public domain. Public domain is where copyright stops. So a lot of people think that public domain should not be an issue. You know, there is no copyright anymore, 70 years after the death of the artist. But actually, it is very important because copyright is there to give the right to incentivize the creation, you know, to make the investment in publishing and producing worth. But actually, where there is a public domain, nobody has a right anymore in that thing. So who will be taking care of publishing that thing, of putting it on the market? Actually, it works, you know. We still publish Shakespeare's play, for instance. There is no copyright anymore, but there are still people interested in reading it. But what is new is that with digital technology, we have an opportunity to make almost everything available to the world and to the people. For instance, you might know the Europeana, the digital European library that is online, where you have a lot of material for libraries all over Europe, and they put this material online for all the people to see. It's completely free. You can browse a lot of amazing material of our cultural heritage. To make sure not being in infringement of copyright, they put only public domain material online. But actually the question is, of course it costs a lot of money. So there is a question of who will be the incentive to put money in public domain availability. You know, either you put public money in libraries to enable them to digitize their collection and put them online. And of course here again, the crisis time in which we are will put that question differently from a country to another. In Norway, they have given a lot of money to digitize collection of libraries. But in Greece, I'm sure that it will not be a priority for the years to come. So we will be at the end with a cultural heritage that will be differently accessible depending from its source and in country it comes from. So this is a real issue. Or we could give some this material to private entrepreneurs, like Google, for instance, that will digitize everything. But are we sure that we want to confide our cultural heritage that has been collected with public libraries over the ages to a private entrepreneur like Google, you know? On what conditions? So these are very strong questions. To give you an example why also the limitation to public domain works is important. In Europeana, for the centenary for the 100th birthday of the First World War, a lot of public libraries in Europe have had a project to put in Europeana all the materials they have on that period. But as the mandate is to comply with copyright, they put only material that are certainly in the public domain. And for instance, I spoke with the Royal Library here in Belgium, and a guy in charge of that project told me that actually it completely distorts the image of the historical image of that war that will be put on Europeana, because to put things that are that are in the public domain means that the author has to be dead by the 1943, sorry. And so that means that actually he would put, for instance, writings by Belgian writers during the World War I. But those writers, if they died before the World War II, were rather old during the World War I. But they would not put writings by young writers, for instance, you know, people who were 20 years old at the time, because their writings will still be in the public, in copyright. And so it means that actually what will be put on Europeana will be only one vision of that war because of that rule of copyright duration. So actually it's not really a transparent way of putting cultural heritage online. The last issue is what I call the digital public lending. So it's still about public libraries. I'm sure that all of you, when you were younger, you went to public libraries to borrow books. And you made your education with public libraries books. And you still do. Maybe some of you still go to public libraries and borrow books once in a while. And this is allowed under copyright, actually. Public libraries don't have to ask permission to copyright owners to lend books, CDs, to their patrons. But this is restricted to tangible items. But what about e-books, for instance? There are a lot of books that are now only sold as e-books. So does that mean that, and copyright doesn't allow for those e-books to be lent to people visiting libraries. So what happens is that publishers have made some agreements with libraries to enable them to lend those books. But it's a market-based initiative. It's not decided by the lawmaker. And so that means that there are some risks for cultural diversity, but it will only be the collection that the publisher wants to put in a public library that will be made available. And I think this is a big problem here because a lot of young people, a lot of people with no much money, will really rely on the offer of public library to get a culture, to get an education, or just for enjoyment, just for leisure, to read for leisure. And this might be completely changed if we don't extend the possibility of public lending to e-books or to digital content. And this is something that copyright should also deal with. So there are some examples where copyright is really at the crossroads between a strong protection of creator that's needed in some way and the digital possibility of extending access to copyrighted works to all and to find some balance between those. Thank you.
Thank you very much, Professor. So any question to connect the work of the two artists we've seen before and their rights as artists? Yes, please.
It will depend. You might have negotiation between authors and producers or authors and publishers. You will have then negotiation between publishers and, for instance, Amazon to put their books online, or with Google, not really, because Google don't ask permission. They do things and then they are sued for copyright infringement, and then they decide to discuss, but they don't discuss before. They just go. So it won't be Google. So you might have a lot, it will be the market. So you will be a lot of negotiation between creators, between people who want to use the work of their creators to make them into products, sellable products. So I don't know if it was your question. No, I'm just a professor having an expertise in copyright, but actually there are a lot of people doing copyright. So when you have, for instance, an author who writes a book and wants the book to be published, the author would find a publisher, and then you will have a discussion between the author and the publisher, and they will sign a contract. And maybe the author will be helped by a lawyer that is also a specialist in copyright, and the publisher will have a legal team, of course, knowing the copyright contract very well. So.
Thank you. My name is Nafissatou. I studied, so I'm a lawyer, specialized in employment and social security. So my question is this one. What do you think about intellectual property in countries, in developing countries? Because we all know that China knew his actual development because of his absence of rules concerning intellectual properties. So what do you think about it for developing countries?
Hello, my name is Laura Lise. I'm from France. I guess the main problem for the copyright is for the moment internet. It's really in danger because of the internet. What do you think? Do you think that we need a legislation, like a harmonized legislation in the EU? Do you think it's going to solve this problem, or if there is another way?
Yeah, actually, intellectual property in developing countries is a very huge question, and at the international level, it was decided a few years ago, almost 20 years ago now, that actually countries who want to join the WTO, for instance, need to have a high level of protection of copyright, also of patent, of trademarks. And this is why actually China now has a big level of copyright protection. It used not to have anything. But actually you're right when you say that economic development also comes from the lack of copyright, because you cite the example of China. But actually, the United States in the 19th century didn't have a strong copyright protection. It has a copyright protection for its own authors, but it didn't recognize the authors coming from other countries. So actually, the copyright publishing industry started to develop just by copying the works of UK, British authors with no copyright protection at all. And it was the industry of publishing in the US very stronger. So you're right by saying that lack of copyright at some point of economic development is also a preliminary to develop its own cultural scene. And the problem with developing countries is that we don't allow them to have this time of transition. We ask them to enforce copyright from the beginning, even before they have an industry emerging. So this is a big problem. As to the internet, actually it's been more than 20 years now that we have been developing laws to answer the issue of copyright on the internet. And some of those laws have solved some issue, but it hasn't solved the piracy issue and the fact that people get access to what they want on the internet. I don't think it's law that will solve that. I think that it's also the industry that needed to react a bit faster. You know, the music industry was very slow in reacting and in proposing music online for many reasons. So it was not always their fault, but it means that people could get on peer-to-peer networks to get the music they wanted, and there were no valid offer from the music industry, no lawful offer. So now it's changing a bit, and I think that it will be changing, and maybe piracy will be lower. But it's not only a matter of law. It's also a matter of market, of business models that need to be developed to provide the services that the people want.